Sometimes you get multiple financial penalties from the local housing authority for what appear to be all the same offences. They're probably not, because they would be very particular about that, and they wouldn't fine you twice for the same thing. So you might find in a HMO that you're being fined for breach of HMO management regulations. You would also find, if it's a licensed property, that you may be getting fined under breach of licence conditions, and some of the things that you've done seem similar or related to something under the management regulation. Really, it shouldn't be like that, but they do, and they capitalise on whatever they can. And especially if you're unlicensed, of course, you're going to get a fine for not being licensed as well, along with breaching management regulations and licence conditions. For most part, currently, the things we see that most people are being fined for by the local housing authority is breach of licence conditions. That could be a selective licence, or it could be a HMO licence. That could be a standard mandatory HMO licence or an additional HMO licence. It is vitally important that you seek professional advice so that any representation that is made against the notice of intention is considered, and any opportunity to reduce the fine or have it quashed completely is taken into consideration. You probably read last year that there were 2 incidents towards the end of the year where a local housing authority didn't have evidence beyond reasonable doubt, but had issued a fine, which means they were breaking the law. They hadn't followed due process. And there was another one where the landlord was guilty, but the council had the fine quashed because the total amount of the fine was in excess of the amount they're allowed to fine you. So it is possible, with good professional help, to get things changed and to reduce them, and obviously to have your mitigation taken into account.